I never thought ice melt would be the thing that finally pushed me over the edge. But there I was, standing in my driveway at 7 in the morning, staring down a woman who looked like she had been waiting her entire life for this exact moment of confrontation. My name is Zachary Pruitt, and I had just moved to Meadowbrook Springs, Connecticut, 6 months earlier. The house was beautiful, the neighborhood seemed quiet, and the price was reasonable for the area. I should have known something was up when the realtor glossed over the HOA details during closing, but I was too excited about finally owning a home to pay much attention. That morning in February, with ice coating my driveway and my breath forming clouds in the frigid air, I was about to learn exactly what I had signed up for. The woman standing at the end of my driveway was holding a clipboard like it was a weapon. She wore a purple puffy coat that made her look twice her actual size, and her blonde hair was styled in that particular way that screamed, "I need to speak to your manager," from a mile away. Her name tag, which she actually wore at 7 in the morning, read Patricia Hendricks, HOA president. "Excuse me," she called out, her voice sharp enough to cut through the cold morning air. "Are you the new owner of 847 Willow Creek Drive?" I looked around, as if there might be someone else she was talking to, then back at her. "Yeah, that's me. Zachary Pruitt. Can I help you with something?" She marched up my driveway with purpose, her boots crunching on the ice I had been about to treat. In her other hand, she held what looked like a bag of my ice melt, the same kind I had just purchased from the hardware store 2 days ago. "Is this yours?" she demanded, holding up the bag like it was evidence in a murder trial. I squinted at it. "I mean, it looks like the same brand I bought, but I am not sure why you would have my ice melt." "I removed it from your property," she said, her chin tilted up in defiance. "This brand of ice melt is not approved by the Meadowbrook Springs Homeowners Association. You are in direct violation of Section 12, Subsection 4, Paragraph C of the Community Guidelines." I blinked. "You took my ice melt." "I confiscated materials that were in violation of HOA regulations," she corrected, as if there was some meaningful difference between the two statements. "Lady, I don't know what you are talking about. It is ice melt. I bought it to melt the ice on my driveway so I don't break my neck walking to my car. What could possibly be against the rules about ice melt?" Patricia's eyes narrowed, and I could see she was gearing up for what was clearly a prepared speech. "The Meadowbrook Springs HOA has very specific regulations regarding de-icing products used on community properties. The brand you purchased, Ice Begone Premium Melt, contains magnesium chloride, which has not been approved by our Environmental Compliance Committee. Only calcium chloride-based products from our approved vendors list may be used." I stood there, holding the spreader I had been about to fill, trying to process what I was hearing. "You have got to be kidding me." "I assure you, Mr. Pruitt, the HOA takes these matters very seriously. The chemicals used in de-icing products can damage our community's landscaping, affect our groundwater, and create inconsistent aesthetic results across the neighborhood. We have these rules for a reason." "But it is the same thing," I protested. "They both melt ice." "That is literally their only job. The approved products have been tested and verified to meet our community standards," Patricia said, her voice taking on a lecturing tone that made me feel like I was being scolded by a particularly aggressive elementary school principal. "You will need to cease using this product immediately and purchase an approved alternative. I have the vendor list here." She pulled a laminated sheet from her clipboard and tried to hand it to me. I did not take it. "And if I don't?" Her smile was cold enough to freeze the already icy driveway. "Then the HOA will be forced to issue fines. $50 per day until you come into compliance. And if you continue to refuse, We have the authority to place a lien on your property." "For ice melt," I said flatly. "For violations of community standards that you agreed to uphold when you purchased your home here," she corrected. I felt my jaw clench. The ice on my driveway was already making it dangerous to walk, and I had to get to work. My car was sitting in the garage, useless, because I could not safely navigate the 15 feet from my front door without risking a fall. And this woman was telling me I could not use the perfectly good ice melt I had already purchased because it wasn't the right brand. "I am going to use my ice melt," I said slowly. "The one I bought. And if you have a problem with that, you can take it up with someone who cares." Patricia's face flushed red, which was impressive considering how cold it was outside. "Mr. Pruitt, I strongly advise you not to take that tone with me. The HOA has successfully enforced these regulations for 15 years, and we have litigated against homeowners who refuse to comply. You will not win this fight." "We will see about that," I muttered, turning back toward my garage where I had another bag of the forbidden ice melt stored. "Consider this your official warning," Patricia called after me. "Documentation will be sent to your registered address within 48 hours. Good day, Mr. Pruitt." I heard her boots crunching back down my driveway as I grabbed the bag of Ice Begone Premium Melt and ripped it open with more force than was strictly necessary. I was not about to let some power-hungry HOA president tell me what brand of ice melt I could use on my own property. I had bought this house. I paid the mortgage, and I would be damned if I was going to slip and break my tailbone because Patricia Hendricks had opinions about magnesium chloride. I spread the ice melt across my driveway with aggressive efficiency, watching with satisfaction as it immediately started working on the thick layer of ice that had formed overnight. The stuff worked great, which was exactly why I had bought it. The employee at the hardware store had recommended it, and it had excellent reviews online. But apparently, none of that mattered to the Meadowbrook Springs HOA. By the time I got to work that morning, I was still fuming. My coworker, David, noticed immediately when I slammed my bag down on my desk with more force than necessary. "Rough morning?" he asked, looking up from his computer screen. "You have no idea," I said, dropping into my chair. "My HOA president confiscated my ice melt this morning." David's eyebrows shot up. "Your what?" I explained the entire interaction, and by the end of it, David was laughing so hard he had tears in his eyes. "It is not funny," I said, though I could feel the absurdity of it starting to hit me too. "It is a little funny," David said, wiping his eyes. "She actually took your ice melt, like physically removed it from your property, and threatened me with daily fines if I use the wrong brand," I confirmed. "Man, that is why I will never buy in an HOA neighborhood," David said, shaking his head. "Those people have way too much time on their hands. What are you going to do?" "I don't know," I admitted. "Probably nothing. I mean, what are they going to do, actually fine me?" For ice melt, as it turned out, yes, they absolutely would. 2 days later, I found an official-looking envelope in my mailbox. Inside was a letter printed on Meadowbrook Springs HOA letterhead, complete with a gold seal that looked like something from a government document. The letter informed me that I had been observed using non-approved de-icing products on my property on February 14th, at approximately 7:15 a.m. I was hereby notified that this constituted a violation of Section 12, Subsection 4, Paragraph C of the Community Guidelines, and that I would be assessed a $50 daily fine beginning on February 16th if I did not come into compliance. The letter was signed by Patricia Hendricks in a flourishing script that took up 3 lines. I crumpled the letter and threw it in the recycling bin. Then I retrieved it, smoothed it out, and read it again. They were serious. They were actually serious about this. The next morning, I woke up to another inch of fresh snow that had fallen overnight. I grabbed my bag of Ice Begone Premium Melt and treated my driveway again, this time making sure to do it at 6 in the morning before Patricia could possibly be up and patrolling the neighborhood. I was not going to be bullied into buying overpriced ice melt from some approved vendor who was probably paying kickbacks to the HOA board. A week later, I received another letter. This one informed me that I now owed $350 in fines for continued violations, and that if payment was not received within 10 days, the HOA would place a lien on my property. That was when I decided to call a lawyer. I found Willow Ortega through a Google search for HOA Attorney Connecticut. Her website was professional but not flashy, and her reviews were overwhelmingly positive, with multiple former clients praising her ability to fight back against overreaching HOA regulations. I called her office that afternoon and was surprised when she answered the phone herself. "Ortega Law, this is Willow," she said in a crisp, professional voice. "Hi, my name is Zachary Pruitt, and I think my HOA is trying to extort me over ice melt." There was a brief pause, and then I heard what might have been a suppressed laugh. "Tell me more." I explained the entire situation, from Patricia's early morning confrontation to the letters threatening liens on my property. Willow listened without interrupting, and I could hear her typing notes as I talked. "Okay," she said when I finished. "First question, did you receive a copy of the HOA's community guidelines when you purchased your home?" "Yeah, it was like 100 pages. I skimmed it." "You still have it?" "Somewhere, yeah. Probably in a box in my basement." "Find it," Willow said. "I need you to locate Section 12, Subsection 4, Paragraph C and send me a photo of the exact language. Also, send me copies of both letters you received from the HOA. Can you do that today?" "Sure, yeah." "But do you think they actually have a case here?" "Honestly, it sounds like bullshit to me," Willow said bluntly. "But HOAs can write pretty much whatever they want into their guidelines, and homeowners technically agree to follow them when they buy property in the community. That doesn't mean the rules are always enforceable, though. Restrictions have to be reasonable, they have to be applied consistently, and they can't violate state or federal law. I will know more once I see the actual language in your HOA documents. So, what should I do in the meantime?" "Keep using your ice melt," Willow said. "Document everything. Take photos of your driveway before and after treatment. Take photos of your neighbors' driveways too, especially if they are using ice melt. Keep every piece of mail you get from the HOA, every email, every contact. And don't pay them anything yet. Once we establish what they can and can't actually enforce, we will go from there." I felt some of the tension leave my shoulders. "Thank you, seriously. This whole thing has been driving me crazy." "That is what they count on," Willow said. "Most people cave because it is easier than fighting. But if you are willing to push back, I think we can make this go away. Send me those documents, and I will review them this weekend. We will set up a proper consultation early next week." I spent that evening digging through boxes in my basement, until I found the massive binder containing the Meadowbrook Springs HOA Community Guidelines. It was even longer than I remembered, easily 200 pages of dense text covering everything from approved house paint colors to the maximum height of mailbox posts. I flipped to Section 12, which was titled Environmental and Grounds Maintenance Standards. Subsection 4 covered winter weather maintenance and de-icing procedures. I skimmed through paragraphs about snow removal timelines and sidewalk clearing requirements until I found paragraph C. It read, All de-icing products used on private driveways, walkways, and property entrances must be selected from the HOA-approved vendors list or pre-approved by the Environmental Compliance Committee. Products containing magnesium chloride, sodium chloride, or other compounds not specifically approved by the committee are prohibited due to potential environmental impact and aesthetic concerns. Homeowners in violation will be subject to fines as outlined in Section 18. I took a photo and sent it to Willow along with scans of both letters from Patricia. Then I flipped to Section 18 to see what exactly they were threatening me with. The fine section was elaborate. It started at $50 per day for first offenses, increased to $100 per day after 30 days of non-compliance, and gave the HOA board authority to place liens and even initiate foreclosure proceedings for persistent and willful violations. There was also language about the HOA's right to enter your property to remedy violations at the homeowner's expense. I took photos of those pages too and sent them to Willow with a message. "This is insane, right? Please tell me this is insane." She responded within 10 minutes. "Got everything." Review in progress. Initial thoughts. Several potential issues with enforceability. Will have full analysis Monday. Try not to worry too much this weekend. Easier said than done. That Saturday, I woke up to find Patricia standing in my driveway again, this time with two other women I did not recognize. One was taking photos of my driveway with a professional-looking camera, while the other held what appeared to be some kind of testing kit. I walked outside in my bathrobe and slippers, not caring that it was barely 8 a.m. on a Saturday morning. "Can I help you ladies?" I called out. Patricia looked up from the clipboard she seemed permanently attached to. "Mr. Pruitt, we are conducting a site inspection to document your continued violations. This is Karen Bloomfield, our HOA secretary, and Jennifer Russo, a chemical consultant we have retained to analyze the composition of ice melt products being used in the community." Karen waved without looking up from her camera. Jennifer knelt down near the edge of my driveway with what looked like a test tube, scraping samples of the ice melt into a container. "You are on my property," I said, "without permission." "The HOA guidelines grant us right of access for inspection purposes related to community violations," Patricia said smoothly. "It is all in Section 9 if you would like to review it." "Get off my property," I said, my voice hard. "Right now." Jennifer stood up quickly, looking uncomfortable. Karen glanced at Patricia, who held her ground for a moment before nodding. "Very well," Patricia said. "We have gathered sufficient evidence for our purposes. You will be receiving updated documentation of violations early next week. I strongly suggest you reconsider your position on this matter, Mr. Pruitt. The HOA has substantial resources, and we will pursue this to whatever extent necessary." "I have a lawyer," I said, "and she is going to tear your ridiculous ice melt rules apart." Patricia's expression did not change, but I saw something flicker in her eyes. Uncertainty, maybe, or just renewed determination. "We will see," she said. "Come along, ladies." I watched them walk down my driveway and climb into Patricia's silver SUV, which had a custom license plate that read HOA Prez. I could not make this stuff up if I tried. As soon as they drove away, I called Willow. It went to voicemail. "Hey, it is Zachary Pruitt. The HOA president just showed up at my house with two other people and took samples of my ice melt. She said something about a chemical consultant. I told them to leave, but they claimed they had right of access for inspections. Call me back when you can." Willow called back within an hour. "Okay, so they are escalating. That is actually good for us." "How is that good?" "Because the more aggressive they get, the more likely they are to overstep their legal authority," Willow explained. This right of access thing, for example. I reviewed Section 9 in the documents you sent me. The language gives them access for specific purposes related to exterior maintenance and emergency situations. Collecting evidence against you for ice melt violations is a stretch at best. And if they entered your property after you explicitly told them to leave, that is potentially trespassing, HOA guidelines or not. So what do? I draft a letter, Willow said. Official legal representation notice, demanding they cease all contact with you directly and communicate only through me. Demanding they dismiss all fines and violations, and putting them on notice that we consider their actions to constitute harassment and potential trespassing. I can have it ready Monday morning. Do it, I said. Whatever it costs, I am done with these people. There is one more thing, Willow said. I did some research on this environmental compliance committee they keep mentioning. According to the HOA bylaws filed with the state, that committee has to have at least 3 members appointed by the board and confirmed by homeowner vote. I pulled the meeting minutes for the last 2 years, which are public record for HOAs. There is no record of any environmental compliance committee being formed, no appointments being made, and no homeowner votes confirming members. I let that sink in. So the committee that is supposed to approve ice melt products does not actually exist, correct? Which means there is no legitimate process for approving or denying products, which means they are enforcing rules based on a non-existent committee's non-existent decisions. That has to be illegal. It is not illegal exactly, but it makes their enforcement of this particular rule invalid. If the committee doesn't exist, they can't have legitimately approved or denied any products. The whole foundation of their violation notice falls apart. I felt a smile spreading across my face for the first time in a week. So we have them. We have a very strong argument, Willow corrected. I am going to spend the weekend building a complete analysis of every potential issue with their enforcement action. The non-existent committee is the biggest one, but there are others. The rules about chemical composition are vague enough that you could argue almost any ice melt violates them. There is no clear process for how homeowners are supposed to request approval for products not on the vendor list. The vendor list itself isn't published anywhere accessible to homeowners. I found about 8 separate issues just from a preliminary review. This is amazing, I said. Thank you. Don't thank me yet, Willow said. We still have work to do. But yeah, I think we are going to be fine. Try to enjoy the rest of your weekend. Easier said than done, but I felt better than I had in days. I spent Saturday afternoon walking around the neighborhood, documenting every driveway that had evidence of ice melt use. Out of 36 houses on my street, I counted 23 that clearly had some kind of de-icing product on their driveways or walkways. I took photos of all of them, making sure to get house numbers in each shot. On Monday morning, I received another letter from the HOA. This one informed me that my total fines now amounted to $600 for continued violations through February 21st. They demanded payment within 5 business days and included a form I could fill out to set up a payment plan if needed. I scanned the letter and sent it to Willow with a message. Another one. How professional does a payment plan option look? She responded. Like they have done this before. Don't worry, sending my letter today. That afternoon, I got a call from a number I did not recognize. I let it go to voicemail. The message was from Patricia, her voice tight with barely controlled anger. Mr. Pruitt, this is Patricia Hendricks. I received a very concerning letter from an attorney claiming to represent you. I need to speak with you directly about these accusations and come to a reasonable resolution before this situation escalates further. Please call me back at this number as soon as possible. I saved the voicemail and forwarded it to Willow. She called me immediately. "Perfect," she said. "She is already rattled. Don't respond to her at all. If she shows up at your house, tell her you are represented by counsel and she needs to contact me. Don't engage beyond that." "What did you put in your letter?" "The truth. That the Environmental Compliance Committee does not exist, that their enforcement is invalid, that they have potentially trespassed on your property, that their vendor list is not publicly accessible, that their rules are unconstitutionally vague, and that if they continue to harass you, we will pursue legal action for damages." Unconstitutionally vague. It is a legal standard. Rules have to be clear enough that a reasonable person can understand what is and is not allowed. Saying products with magnesium chloride are banned, but not providing clear guidance on acceptable alternatives, not making the vendor list easily accessible, and having no functional approval process all add up to a rule that is too vague to be fairly enforced. "I love it," I said. "The HOA has 10 business days to respond to my letter. If they dismiss the violations and fines, this goes away. If they double down, we take it to the next level." Patricia called 2 more times that day. I did not answer either time. She did not leave any more voicemails, but I could see her trying to call. On Tuesday, I got an email from the HOA's general email address asking me to contact them urgently regarding important community matters. I forwarded it to Willow without responding. Wednesday morning, I received a certified letter that required a signature. The return address was from a law firm in Hartford, Morrison, Chen and Associates. My stomach dropped as I signed for it and tore open the envelope. The letter was from an attorney named Richard Morrison, who identified himself as counsel for the Meadowbrook Springs HOA. It was 3 pages of dense legal language, but the gist was clear. The HOA rejected all of my attorney's claims, maintained that their enforcement actions were valid and proper, and demanded immediate payment of all assessed fines, plus an additional $200 in administrative fees for requiring them to retain legal counsel. They gave me 5 days to comply before proceeding with a lien on my property. I called Willow immediately. "They lawyered up," I said. "Good," Willow said. "Send me the letter and breathe. This is completely normal. HOAs always think hiring a lawyer will scare people into backing down." "It is kind of working," I admitted. "It shouldn't. Their attorney is just repeating their same invalid arguments in fancier language. Let me review the letter and I will call you back within an hour." True to her word, Willow called back 50 minutes later. "Okay, so Richard Morrison is a hack who does basic HOA work for probably a dozen communities in the area," she said. "His letter is all posturing and no substance. He does not address any of the specific issues I raised, just makes blanket statements about the HOA's authority. He is hoping you will fold. We are not folding. So what now? Now I draft a response eviscerating his letter point by point, and I file a declaratory judgment action in Superior Court. We are going to ask a judge to rule that the HOA's enforcement of this particular rule is invalid and unenforceable. We will also ask for attorney fees under Connecticut's HOA statute, which allows homeowners to recover legal costs when an HOA acts unreasonably. How much is this going to cost me?" Willow was quiet for a moment. "I am going to be straight with you. If this goes to actual court, you are looking at probably $5,000 to $10,000 in legal fees, depending on how hard they fight. But here's the thing. I don't think it will get that far. Once we file the action and a judge sees what they are trying to enforce, I think there is a very good chance the judge tells them to knock it off and awards you fees. And if by some miracle we go to trial and lose, You are out the legal fees, but you will have established a record for appeal. But I could also win and get my attorney fees back. Exactly. And I think our chances of winning are very good. Better than good, honestly. But I need you to understand the risk before we move forward. I thought about it for about 10 seconds. Do it. File everything. I am not letting them bully me into paying bogus fines. That is what I was hoping you would say. I will have the complaint drafted by end of business tomorrow, and we will file Friday. They are going to lose their minds when they get served. She was right about that. The following Tuesday, I came home from work to find Patricia standing on my front porch with Richard Morrison, the attorney from the letter. Behind them stood two other people I recognized from HOA meetings I had been forced to attend: Marcus Webb, the HOA vice president, and Karen Bloomfield, the secretary who had taken photos of my driveway. "Mr. Pruitt," Patricia said as I got out of my car, "we need to speak with you about the lawsuit you filed." "No, we don't," I said, walking toward my front door. "I am represented by counsel. You know that. You need to contact my attorney." Richard Morrison stepped forward, holding up his hands in what was probably meant to be a placating gesture. "Mr. Pruitt, I think there has been a significant misunderstanding here. We are prepared to offer you a very reasonable resolution to avoid unnecessary litigation." "Contact my attorney," I repeated, pulling out my keys. "If you would just listen for one moment," Patricia said, her voice rising. "This lawsuit is absurd. You are wasting everyone's time and money over a simple request to follow community guidelines that every other homeowner follows without complaint." I turned to face her. "Every other homeowner. I have photos of 23 houses on this street alone using ice melt." "Are you fining all of them too? Or just me?" Patricia's face flushed. "Those homeowners are using approved products." "Really? You personally verified the chemical composition of ice melt at 23 houses. That is impressive work." "Mr. Pruitt, this hostility is unnecessary," Marcus said, speaking for the first time. He was a tall man with gray hair and an expensive suit, the kind of guy who probably thought of himself as very reasonable. "We are here in good faith to resolve this matter. The HOA is prepared to waive all fines assessed to date if you simply agree to use approved products going forward and withdraw your lawsuit." "Not interested," I said. "Contact my attorney if you want to make offers." "We are trying to save you money," Karen said. "Legal fees are expensive. Just use different ice melt and this all goes away." "I shouldn't have to use different ice melt because your made-up committee that doesn't actually exist didn't approve the perfectly good product I already bought," I said. "Now get off my porch." Patricia's expression hardened. "You are making a serious mistake." "So are you. Get off my property before I call the police and report you for trespassing." Richard Morrison pulled a business card from his pocket and held it out. "Please, at least take my card. If you want to discuss settlement terms, you can reach me directly." "My attorney has your contact information," I said, not taking the card. "Use it." I walked past them, unlocked my door, and went inside without looking back. Through the window, I watched them stand on my porch for another minute, having what looked like an intense discussion, before finally walking back to their cars. As soon as they left, I called Willow and told her what happened. "They are panicking," she said, and I could hear the satisfaction in her voice. "They know they are going to lose. The fact that they came to your house with their attorney to try to pressure you into settling is borderline witness intimidation. Document it. Write down everything you remember about the conversation, exact quotes if you can. They offered to waive all the fines if I dropped the lawsuit and agree to use their approved products. Of course they did. They want this to go away before a judge looks at it. We are not taking that deal." They don't get to fine you $600 for nothing, realize they are going to lose in court, and then pretend they are doing you a favor by waiving the fines they never should have charged in the first place. So, what do? We respond to their settlement offer in writing, through their attorney, rejecting it and reiterating our demand that they dismiss all violations, acknowledge their enforcement was invalid, and pay your attorney fees. Then, we proceed with the lawsuit. How long until we actually get in front of a judge? The initial hearing is scheduled for April 3rd. That is just a case management conference where the judge will hear basic arguments from both sides and set a schedule. Actual trial, if it gets that far, would be probably 6 to 8 months out. But I don't think it will get that far. She was partially right. The case did not make it to trial, but not for the reasons either of us expected. Over the next few weeks, my mailbox became a battleground. I received no fewer than 7 different letters from the HOA and their attorney, each one more threatening than the last. They claimed I was acting in bad faith. They claimed my lawsuit was frivolous and they would pursue sanctions. They claimed I was damaging property values for the entire community. They even sent a letter to all my neighbors informing them that I was engaged in litigation against the HOA and that my actions could result in increased dues for everyone. That last letter backfired spectacularly. Within 2 days, I had 3 neighbors knock on my door to ask what was going on. When I explained the situation, all 3 were baffled that the HOA was making such a big deal out of ice melt. One of them, a woman named Rebecca who lived 2 houses down, told me she had been using the exact same brand I was using and had never received any complaints. I have been here 8 years, she said. I have always used Ice Begone. It is the best stuff on the market. I didn't even know there was an approved list. I asked if she would be willing to put that in writing, and she agreed. I took her statement to Willow, who immediately incorporated it into our court filings. "This is gold," Willow said. "It proves they are selectively enforcing." That is a huge problem for them. Selective enforcement is one of the fastest ways to get an HOA rule thrown out. Should we find more neighbors who are using unapproved products? Absolutely. Talk to as many people as you can. Get statements from anyone willing to provide them. I spent the next weekend going door to door on my street. Out of the 23 houses I had photographed using ice melt, I was able to talk to owners or residents at 17 of them. 9 admitted they were using Ice Begone or similar products not on the approved vendor list. 8 said they bought whatever ice melt was on sale at the local hardware store and had never checked an approved list because they didn't know one existed. 6 people agreed to provide written statements. One guy, an older man named George who lived at the end of the street, told me he had been on the HOA board 5 years ago when they first tried to implement the ice melt restrictions. "It was Patricia's idea," he said. "She got kickbacks from one of the approved vendors. They paid for her to go to some HOA conference in Florida, and suddenly she was pushing hard for these environmental compliance rules. Most of us thought it was stupid, but she wore everyone down until they voted for it." "You have any proof of that?" I asked. George shook his head. "It was all unofficial, but everyone knew what was happening. That is why I quit the board. Too much corruption, too much nonsense." I reported all of this to Willow, who dug deeper. She filed a Freedom of Information Act request with the town for any records related to HOA meetings and vendor relationships. She also subpoenaed the HOA's financial records as part of our lawsuit discovery process. What she found was explosive. In March, about a week before our scheduled court hearing, Willow called me with an edge of excitement in her voice I had not heard before. "Zachary, we need to meet. Today if possible. I found something big." I met her at her office an hour later. She had documents spread across her conference table, highlighted and marked with sticky notes. "Okay," she said, gesturing to the papers. "So I got the HOA's financial records. I was looking for evidence of the kickback George mentioned, and I found it. Sort of. Sort of. Patricia Hendricks has been receiving payments from a company called Eco Melt Solutions for the last 3 years. They are listed as consulting fees. Guess who owns Eco Melt Solutions? Patricia, her husband, Donald Hendricks. And guess which company is the primary approved vendor on the HOA's ice melt list? I felt my eyes widen. Eco Melt Solutions. Exactly. Patricia has been enforcing rules that directly benefit her husband's company. That is a textbook conflict of interest. It might also be fraud, depending on how we want to argue it. Holy shit. It gets better. I pulled Eco Melt's business filings. The company was formed 6 months before the HOA passed the ice melt restrictions. Patricia was already on the board at that point. She helped write the restrictions, pushed for their approval, and has been enforcing them aggressively ever since, all while her husband's company profits from being the primary approved vendor. That has to be illegal. It violates the HOA's own conflict of interest policies, which are in their bylaws. It probably violates Connecticut's fiduciary duty statutes for HOA board members. And depending on how much money is involved, it could potentially be criminal fraud. How much money are we talking about? Willow flipped through some papers. Based on the financial records, Eco Melt Solutions has received approximately $48,000 in payments from Meadowbrook Springs residents over the last 3 years, and that is just ice melt. They also sell other approved products, fertilizers and weed killers, and such, that are on various other approved vendor lists Patricia has pushed through. I sat down heavily in one of the conference room chairs. So this whole thing, all of it, was just a scheme to force people to buy from her husband's company. That is what it looks like, and you were probably targeted specifically because you are new. New homeowners are less likely to know about the approved vendor lists, more likely to buy random products from hardware stores, and therefore more likely to violate the rules. You fine a few new homeowners aggressively, word gets around, and everyone else falls in line and buys from the approved vendors out of fear. We have to take this to the police. We will. But first, we take it to the judge. Our hearing is in 5 days. I am going to file an emergency motion to present this evidence and ask for sanctions against Patricia personally and the HOA board for fraud. The judge is not going to be happy about this. What kind of sanctions? Monetary penalties, removal from the board, possible referral for criminal prosecution. This is bad, Zachary. What Patricia did is really bad. The emergency motion hearing was scheduled for March 28th at 2 p.m. Willow filed her motion with all the supporting evidence on March 26th, giving the HOA's attorney less than 2 days to respond. Richard Morrison called Willow on the morning of the 27th. She put the call on speaker so I could listen in. "Willow, we need to talk about this motion," Richard said. He sounded tired. "I am happy to talk. What did you want to discuss? These allegations against Mrs. Hendricks are extremely serious and frankly irresponsible. You are accusing her of fraud based on circumstantial financial connections that have perfectly innocent explanations." Richard, her husband, owns the primary approved vendor, and she enforces the rules requiring homeowners to buy from approved vendors. There is nothing circumstantial about that. It is a blatant conflict of interest. The HOA board disclosed all vendor relationships in their annual reports. They disclosed that Eco Melt Solutions was an approved vendor. They did not disclose that Patricia Hendricks, the HOA president, is married to the owner. That is the conflict. You know that. There was a long pause. What do you want? Complete dismissal of all charges against my client. Acknowledgement in writing that the enforcement was improper. Full refund of any money my client has paid to the HOA related to this matter. Payment of all attorney fees, and Patricia Hendricks's resignation from the board. That is not going to happen. Then we will see you in court tomorrow. Willow, be reasonable. You are going to destroy this woman's reputation over ice melt. No, Richard. Patricia destroyed her own reputation by running a corrupt scheme to enrich her family while abusing her position of authority. I am just pointing it out. If you want to settle, you know my terms. Richard hung up without saying goodbye. The hearing the next day was unlike anything I expected. I had never been in a courtroom before, and I was nervous as Willow, and I took our seats at the plaintiff's table. Richard Morrison sat at the defense table with Patricia Hendricks next to him. Patricia looked furious, her face set in hard lines, but I noticed her hands were shaking slightly as she shuffled through papers. Judge Linda Martinez entered, and everyone stood. She was a middle-aged black woman with sharp eyes and an expression that suggested she did not suffer fools. "Please be seated," she said, settling into her chair and pulling the case file in front of her. "I have reviewed the complaint, the defendant's answer, and the plaintiff's emergency motion. Mr. Morrison, I will hear from you first. Please explain to me why your client has been fining Mr. Pruitt for using a particular brand of ice melt." Richard stood. "Your Honor, this case involves straightforward enforcement of duly enacted community guidelines that Mr. Pruitt agreed to follow when he purchased property in Meadowbrook Springs. The HOA has legitimate environmental and aesthetic concerns about de-icing products, and they have established a reasonable approval process to address those concerns. Mr. Pruitt refused to comply despite multiple notices, and the HOA was forced to assess fines in accordance with their enforcement procedures." "I see. And where can homeowners find this approved vendor list?" Richard hesitated. "It is available through the HOA office." "Is it published on a website, included in welcome packets for new homeowners, posted in any common areas?" "I believe it is available upon request." "So a homeowner has to know the list exists and specifically ask for it." "The guidelines reference the list, Your Honor." "Homeowners are expected to familiarize themselves with the guidelines." Judge Martinez flipped through some papers. "I am looking at Section 12, Subsection 4, Paragraph C. It says products must be selected from the approved vendors list or pre-approved by the Environmental Compliance Committee." "Miss Ortega, you claim this committee does not exist." Willow stood. "That is correct, Your Honor. I have reviewed 3 years of HOA meeting minutes which are public record. There is no record of this committee being formed, no appointments being made, no homeowner votes confirming members, and no meeting minutes from any committee meetings. The HOA bylaws require committees to be properly established and documented. This one was not. Mr. Morrison." Richard looked at Patricia, who whispered something to him. "Your Honor, the committee operates on an as-needed basis. The board members serve as the committee when review of products is required. So the committee is just the board under a different name. In practical terms, yes. And the board members have expertise in environmental chemistry. They are qualified to evaluate the environmental impact of de-icing compounds. They consult with experts when necessary." "I see. Miss Ortega, let us discuss your emergency motion. You allege that Mrs. Hendricks has a conflict of interest because her husband owns one of the approved vendors." "Yes, Your Honor. The primary approved vendor for ice melt products is Eco Melt Solutions, owned by Donald Hendricks. Mrs. Hendricks is the HOA president and has been the primary enforcer of these product restrictions. HOA financial records show that residents have paid approximately $48,000 to Eco Melt Solutions over the last 3 years. This was not properly disclosed as a conflict of interest, and it violates the HOA's own bylaws regarding board member conflicts. Judge Martinez turned to Patricia. Mrs. Hendricks, is it true your husband owns Eco Melt Solutions? Patricia stood, ignoring Richard Morrison's attempt to stop her. Yes, Your Honor, but I don't see how that is relevant. My husband is a businessman. I am a volunteer board member trying to maintain community standards. There is no connection between those two things. You don't see a connection between your enforcement of rules requiring homeowners to buy from your husband's company and your husband's company receiving $48,000 from those homeowners. We have multiple approved vendors. Homeowners have choices. Willow stood again. Your Honor, I have the approved vendors list. There are 3 companies listed for ice melt products. Eco Melt Solutions, owned by Mr. Hendricks. Arctic Snow Services, which went out of business in 2023 according to Connecticut business records. And Northern Safety Products, which according to their website only sells in bulk quantities of 500 pounds or more, making them impractical for residential use. In practice, Eco Melt is the only realistic option. Judge Martinez's expression hardened. Mr. Morrison, this looks very bad for your client. Your Honor, I was not aware of the full scope of Mrs. Hendricks's business connections when I agreed to represent the HOA in this matter. I request a continuance to properly investigate these allegations. Motion denied. This is a simple declaratory judgment action about whether the HOA can enforce ice melt restrictions. The conflict of interest issue is directly relevant to that question. Here is my ruling. The HOA's enforcement of Section 12, subsection 4, paragraph C against Mr. Pruitt is invalid and unenforceable. The Environmental Compliance Committee does not legally exist. The approved vendors list is not reasonably accessible to homeowners, and the restrictions appear to have been enacted and enforced for the primary purpose of benefiting Mrs. Hendricks's family financially rather than for any legitimate community purpose. Patricia made a strangled sound, but Judge Martinez continued. All fines assessed against Mr. Pruitt are dismissed. The HOA is ordered to pay Mr. Pruitt's attorney fees and costs, amount to be determined after Ms. Ortega submits billing records. Furthermore, I am ordering the HOA board to conduct a special meeting within 30 days to review all vendor approval policies and conflict of interest procedures. Mrs. Hendricks, I strongly suggest you recuse yourself from any discussions involving vendor approvals. Finally, I am referring this matter to the Connecticut State's Attorney's Office for investigation of potential fraud. This hearing is adjourned. The gavel came down with a sharp crack. I sat frozen in my chair, barely able to process what had just happened. Willow was grinning as she gathered her papers. Across the aisle, Patricia's face had gone pale, and Richard Morrison was whispering urgently to her. Did we just win? I asked Willow quietly. We just won, she confirmed. Completely, and they are going to be investigated for fraud. That is better than I expected. As we walked out of the courtroom, Patricia caught up with us in the hallway. Her composure had cracked and she looked desperate. This is not over, she hissed at me. You have no idea what you have done. You are going to regret this. Mrs. Hendricks, Willow said sharply. That sounds an awful lot like a threat. In front of witnesses. I suggest you walk away before you make things worse for yourself. Patricia opened her mouth, closed it, then turned and stormed down the hallway. "Should I be worried?" I asked. "No," Willow said. "She is just panicking because her scheme fell apart. The state's attorney is going to investigate, and based on what we found, I would be shocked if charges aren't filed. She is looking at potential fraud charges, maybe tax evasion if they find she didn't report the eco-melt income properly, and definitely removal from the HOA board." Over the next few weeks, the fallout was spectacular. The story hit the local news after a reporter got wind of the court case. HOA president accused of fraud over ice melt scheme was the headline in the Hartford Courant. The TV news stations picked it up, and suddenly, Patricia Hendricks was the face of HOA corruption in Connecticut. The Meadowbrook Springs HOA board held an emergency meeting and voted unanimously to remove Patricia as president. She resigned from the board entirely 2 days later. Her husband's company, Eco Melt Solutions, lost its contracts with 4 other HOA communities in the area after the news broke. In April, the Connecticut state's attorney filed charges against Patricia for fraud and breach of fiduciary duty. The investigation revealed that she had been running similar vendor approval schemes in 2 other communities where she had previously served on HOA boards. The total amount of money involved across all 3 communities was over $200,000. Patricia pleaded guilty in July to avoid trial. She was sentenced to 2 years in prison, with all but 6 months suspended, 3 years of probation, and ordered to pay restitution to all 3 HOA communities. Her husband's company filed for bankruptcy. As for me, I received a check from the Meadowbrook Springs HOA in May for my attorney fees, $12,347.63. Willow had been thorough in documenting every hour she spent on my case. The HOA also sent me a formal letter of apology, signed by the new board president, Marcus Webb, who had apparently known nothing about Patricia's scheme. The letter acknowledged that their enforcement actions against me were improper and assured me that all vendor approval policies had been reviewed and reformed. The approved vendors list was now published on the HOA website, accessible to all homeowners, and included a clear process for requesting approval of alternative products. I still use Ice Begone Premium Melt. It works great, and nobody complains about it anymore. The whole experience taught me a valuable lesson about HOAs and the importance of standing up to petty tyranny. Patricia had counted on me being too intimidated or too cheap to fight back. She had probably successfully bullied dozens of other homeowners over the years, collecting fines and forcing people to buy from her husband's company. But she picked the wrong person this time. I was stubborn enough to refuse to back down, and I found a lawyer who was willing to dig deep enough to uncover the truth. In September, I received a Facebook message from Rebecca, my neighbor who had provided one of the written statements. She told me that at least 5 other homeowners had contacted attorneys after seeing what happened with my case, and they were pursuing their own actions against the HOA for various improper fines and assessments from Patricia's time as president. The whole corrupt system she had built was crumbling. I ran into George, the former board member, at the grocery store in October. He shook my hand enthusiastically. "You did what the rest of us were too chicken to do," he said. "Patricia ran that HOA like her personal fiefdom for years. Everyone knew something was off, but nobody wanted to deal with the hassle of fighting her. Thank you for having the guts to do it." "I just wanted to use my ice melt," I said. "Sometimes that is all it takes," George said. "One person refusing to accept the nonsense." The new HOA board turned out to be much more reasonable. They repealed several of Patricia's more ridiculous rules, including restrictions on what type of bird feeders were allowed, and a bizarre regulation requiring all outdoor furniture to be stored out of sight when not in use. They also implemented term limits for board members and strengthened conflict of interest policies to prevent anything like Patricia's scheme from happening again. I even attended a few board meetings, just to stay informed about what was happening in the community. The whole atmosphere was different without Patricia. People actually discussed issues reasonably instead of being lectured about violations and fines. In November, I received a letter from the Connecticut State's Attorney's Office thanking me for my cooperation in their investigation and informing me that Patricia had begun serving her sentence. The letter also mentioned that their investigation had led to reforms in HOA oversight laws at the state level, requiring more transparency in vendor relationships and stronger conflict of interest protections. I framed that letter and hung it in my home office, right next to the Judge Martinez's order dismissing all violations against me. Looking back, the whole thing seems almost surreal. I moved to Meadowbrook Springs expecting a quiet suburban life, and I ended up taking down a corrupt HOA president over ice melt. It sounds like something from a movie, except it really happened. The experience also made me much more aware of HOA issues in general. I started following news stories about HOA abuses, and I was shocked by how common they are. People getting fined thousands of dollars for having the wrong color mailbox. Families being threatened with foreclosure for leaving their trash cans visible from the street. Elderly homeowners being harassed for not mowing their lawns to exact specifications. HOAs have way too much power and way too little oversight. They can fine you, place liens on your property, and even foreclose on your home, all without any real due process or accountability. And the people who end up running HOAs are often exactly the kind of petty tyrants who shouldn't have that kind of authority. But the experience also taught me that these people are not invincible. Their rules are not always enforceable. And if you are willing to stand up to them, preferably with a good lawyer by your side, you can win. I still live in Meadowbrook Springs. My driveway is currently covered in ice-begone premium melt, which continues to work excellently. The HOA has not bothered me about it, or about anything else. Patricia Hendricks is out of prison now, serving the remainder of her sentence on probation. I heard she moved to a different state, probably to escape the local notoriety. I don't think about her much anymore. What I do think about is how close I came to just paying the fines and switching ice melt brands to make the problem go away. That is what Patricia counted on. That is how her scheme worked. Most people don't want the hassle of fighting, so they comply, even when the rules are stupid and the enforcement is corrupt. I am glad I fought, not just for myself, but for every other homeowner in Meadowbrook Springs who Patricia had bullied over the years. And for everyone else dealing with power-hungry HOA boards who think they can do whatever they want. Sometimes you have to stand up to bullies, even when it is inconvenient. Even when it costs money and time and stress. Because if nobody ever stands up to them, they keep getting away with it. And that is the story of how my HOA tried to fine me $600 for using the wrong brand of ice melt, and how my lawyer discovered they were running a fraud scheme. It started with ice and ended with criminal charges. Not bad for a Tuesday morning in February. These days, whenever someone mentions they are thinking about buying a house in an HOA community, I tell them this story. Some of them laugh. Some of them look horrified. All of them pay a lot more attention to those community guidelines before they sign anything. As for me, I learned my lesson. I read every single word of any HOA document I ever have to sign. I attend board meetings regularly. I vote in HOA elections. And I make sure my neighbors know that if the board ever tries to pull anything shady, there are people in the community who will push back. The ice melt sits in my garage, ready for the next winter storm. Just a simple bag of magnesium chloride-based de-icing compound. To most people, it is nothing special. But to me, it represents something bigger. It represents the importance of standing up for yourself, even over something small. Because sometimes the small things matter most, and I never, ever have to worry about slipping on my driveway again. The ice melts just fine, exactly the way it should, no HOA approval required.